Madam Chief Justice, and may it please the court. My name is Sophia again, and I am here on behalf of the respondent, the United States government, to demonstrate that the appellant, Ms. Nelson, has effectively relinquished her United States citizenship. And my co-counsel, Angela Romero, will be showing how Ms. Innocent committed treason. My other co-counsel, Edward Rickford, shall show how Ms. Innocent's actions mark her as an enemy combatant. And my Catherine Chow will rebut. Today I will refer to the Nationality Act and the Calquita v. United States case to support how Ms. Innocent has relinquished her citizenship. The applicable part of the Nationality Act is that she may relinquish her citizenship by voluntarily taking an oath or making an affirmation or other formal declaration of allegiance to a foreign state after having attained the age of 18 years old, with the intention of relinquishing her United States citizenship. Now, upon reaching the age 18, Naso Innocent signed the Indonesian exclusive loyalty oath, affirming her alliance to Indonesia.
Counsel, Ms. Innocent's attorneys have argued that for signing that oath, she really had no choice. She did not exercise discretion. How do you respond to that?
Well, Your Honor, Ms. Innocent is an 18-year-old, at which age one is usually considered a young adult, but an adult nonetheless. And at 18 years old, in the United States, one may get a credit card, drive a car, sign contracts, and in Indonesia, it seems to be a magic number as well, as she can sign contracts, sign formal government documented forms, and she did so at the age of 18. And also, the oath is a formal oath that is a government official government document, which is unlike Calquita's family registry in the census. And it is also voluntary, as no one is tying her down to the chair and forcing her to sign it.
Your counsel, couldn't you say that she was almost metaphorically tied down to the chair, as you say it, because of the restraints put on her by her family?
Well, Your Honor, her father is quite wealthy, and generally speaking, a wealthy family has money put aside for rainy day schedules, and also as an 18-year-old, one can most likely get a job themselves, and therefore she is not necessarily emotionally compelled to sign the exclusive loyalty oath. And now we will look at intent of her intent of whether or not she has intent to relinquish her citizenship. One may infer the intent from actions, as it is impossible to know exactly what one is thinking. Now, she signed the exclusive loyalty oath, which is an action, pledging her loyalty to Indonesia while she said she felt no loyalty whatsoever to the United States. This goes to show her intent that she does not care for the United States, and therefore is less likely to keep her citizenship.
Well, counsel, let me interrupt you for a minute. Simply because she assigned the oath of allegiance with Indonesia, how do you turn that around and say by doing that she also renounced her citizenship by the United States? Does one necessarily reflect the other? Yes. The fact that she signed this oath of allegiance or loyalty to Indonesia, does that necessarily mean that she has renounced or relinquished her citizenship rights? How do you see that the two relate to each other? Isn't it just a fact that maybe she just has dual citizenship?
Your Honor, regarding dual citizenship, although according to the international law, one may have dual citizenship. However, she only used the citizenship when she thought about coming to the United States for her college education. She was only using it for her college education. She even stated that she gave her citizenship little thought until she sought permission to enter the country for her college education. Now, as Mr. Justice Douglas stated in the Kawakita case, one may not use their dual citizenship as their letter citizenship. And now, also innocent was using it as their letter citizenship as she was not holding responsibility to the United States and only seeking to take advantage of the college system here in the United States. And for these reasons, I urge the court to rule in favor of the respondent, and now my co-counsel, Angela Romero, will address Ms. Nasso's treason. Thank you.
Madam Chief Justice, and may it please the court, my name is Angela Romero, and I'm here to show that Ms. Nasso is innocent as committed treason. Under the constitutional definition of treason, it states that treason against the United States shall only consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. And the case laws in Calicut and Howe show that the necessary element of treason is intent of committing the treasonous act. Your Honor, the facts show that Ms. Nasso innocent is knowledgeable about many things. She is knowledgeable that Jihad-Sam is a militant, radical, anti-American who has outspoken views. And she has also been living beside him and has been his girlfriend. Your Honor, she was also knowledgeable that the 2 parts that she bought was not only suspicious, but also that they could not even be used for a ham radio. In addition to that ham radio, a ham radio at this time is almost, is not something to be used at this time. You can use the internet, you can use cell phones. There's so many different modes of communication, yet Mr. Jihad-Sam asked for her to buy a ham radio.
Also, what do you make of the argument that the defendant here was just acting out of trust for her boyfriend?
Your Honor, the opposing counsel argued that a successful relationship is based on trust. Your Honor, you also posed that blindly trusting in someone that you have an intimate relationship is questionable. You cannot weigh blindly trusting into someone you know and common sense or any reasonable person, an educated person in this situation would have seen all these suspicious signs and warning signs coming up to this point and stopped in buying these parts.
But doesn't the fact that she had this trust mean that she didn't intend to commit any treason, that she had no formed mental thought process that, hey, this might be doing something against the United States?
Your Honor, though that is plausible, any person or a person in her situation would argue that he or she is just trusting in that person. Yet there are so many signs that show that she was ignorant of the signs and just continued in buying these 2 parts. Continuing on, she was also knowledgeable that that it was suspicious for her. It was suspicious for him to be asking her to be buying these 2 parts. He said that he was too scared or fearful of being subject to discrimination. Yet he speaks well English. He dresses Western style. He's adapted to the American culture, and yet Ms. Nasso is Indonesian, and she also speaks well English. There is no difference between the 2, yet he still asked her to buy these 2 parts. Also, she is knowledgeable about the 9/11 situation, the greatest terrorist attack against the United States that only happened maybe only 10 days prior to her buying these 2 parts.
Counsel, how much weight should we give to the fact that just buying some radio parts would otherwise be a wholly innocent thing? So how much weight should we give to that, and why?
Your Honor, in the Howe case, in both Howe and Calicut, Justice Douglas has said that it may appear innocent on its face, yes, yet if examined in light of its purpose and context, it can be treasonable. Just like in Howe, Howe also mentioned Kramer, so both the Kramer and Howe case seemed as innocent on its face, just as just buying these 2 parts for a boyfriend. Your Honor, it says that, or in Kramer, it seemed that he was just having a private conversation with another person, and in help, it seemed like a father was just opening a family door to a son. Yet when you examine in light of its purpose and context, they were knowledgeable about the treasonable character.
So as a public policy reason, should we continue to abide by Haupt in those cases, or should we revisit whether a wholly innocent act can constitute treason?
Your Honor, it's not just wholly innocent on its face. I urge the court to find that anything innocent on its face could or could not be treasonable if you examine closely. If we examine closely in our case, Ms. Not So Innocent ignored all these different signs, and any person in her situation would have connected the dots, would have deduced something suspicious, especially because the time and the reason why Jihad asked her to buy these parts, and multiple other suspicions surrounding the situation. Furthermore, in Calcutta, Mr. Calcutta was charged guilty of treason because of 8 nefarious acts. Yet, we do not need to find anyone guilty of treason because they committed such nefarious acts as Calcutta, or something that's, if she was actually Jihad who was directly involved in a terrorist attack. Your Honor, any act, whether minute or minuscule, can be treasonable if you examine in light of its context and purpose. Also, in Calcutta, though it was overwhelming, we have overwhelming evidence. She is not only knowledgeable, but she's in a position where any reasonable person would not continue in fighting these 2 parties. And therefore, I urge the court to hold in favor of the United States. And now my co-counsel, Edward Rickford, will discuss the issue of pending combat.
Madam Chief Justice, and may it please the court, my name is Edward Rickford, and I'm here to show that Nassau Innocent should be tried as an enemy combatant. The terrible events of 9/11 made us realize that we have some enemies who are so dedicated to destroying America, they will kill defenseless civilians. In order to protect this country, the President wrote the executive order. This order mandates that any individual who is not a United States citizen shall be subject to this order if there is reason to believe that individual is or were a member of the organization known as Al-Qaeda. There is more than enough reason to believe that Nassau Innocent is affiliated with Al-Qaeda. Her boyfriend was arrested with possible links to Al-Qaeda. The order then goes on to state that any individual who is engaged in acts of international terrorism shall be tried as an enemy combatant. The appellant has tried to refute this, but there is no denying that buying the components for a dirty bomb is an act of terrorism. Had the bomb been detonated, it would have produced terrible consequences in the aftermath of 9/11. The last part of the executive order states that if it is in the interest of the United States, an individual shall be subject to the order. Given that there is so much sensitive information involved in the case, it is in the best interest of the United States to try her as an enemy combatant.
Counsel, I understand your point, but if that's true, wouldn't it always be in the best interest of the government to basically presume everybody's an enemy combatant?
Your Honor, I don't believe that's true. She is very likely that she has affiliations with Al-Qaeda, and in light of that, we must treat her differently than we would treat ordinary citizens.
But Ms. Innocent's attorneys are saying there's no evidence that is in the record that we could rely on to even get through the first hurdle.
Your Honor, her boyfriend was arrested with ties to Al-Qaeda. It is unreasonable to think that Eva Braun knew nothing of Hitler's war effort. Trying her in a military tribunal will make sure that the sensitive information involved in this case can be released safely and discreetly. The U.S. government always has the best interest of the United States people at its heart, and we do not want to cause a national panic by releasing such sensitive information in a civilian court. This is a time of war, and we must show great deference to the executive branch of government in times of war. As evidenced by the Hamdi case. The Hamdi case shows us that the legislative branch and the executive branch are both very important. The legislative branch and the judicial branch of government are both very important. But we cannot always count on the three branches of government to work in perfect concert. Because of this, we show high deference to the executive branch of government in times of war. Because of this, the President's executive order must be shown the proper legal respect in Nassau Anderson's case. It is only logical to try Nassau Anderson in a military tribunal. She will still have rights as she would in the civilian court. She will still be guilty. She will still have the right to be guilty until proven. She'll be innocent until proven guilty. And she will still have rights to adequate food and water and adequate shelter. And
Counsel, let me interrupt for a minute. I appreciate that the President has certain powers that do not carry over into other branches of government, but are you saying that the determination by the government that someone is an enemy combatant is the last word and should not be reviewed by anybody else?
Your Honor, I'm simply saying that when there's enough evidence to believe that somebody is an enemy combatant, it is useless for there to be more review.
Why?
Because Your Honor, because the evidence has already been demonstrated that she's an enemy combatant. And another right she'd have in a military tribunal is the right to choose her own lawyer. She'd have to choose a lawyer with the proper military claims, but this would only be good for her. A lawyer with proper military claims would not only be able to defend her, but he'd also have good military background. He could maybe even have a JAG background. There's nothing to say that having a military lawyer is a bad thing.
Doesn't it inherently limit her choices?
Please restate your question, Your Honor.
I mean, even though a military lawyer may in fact be competent, doesn't the fact that she can't choose her own lawyer take away some of her rights?
Your Honor, I don't believe that to be true. I think that it reflects poorly upon her current lawyer that he does not have a military clearance, that something seems a little bit wrong with him, that he cannot get the military clearance necessary to defend her in court. For this reason and others, I urge the court to rule in favor of the U.S. government.
Thank you, Mr. Riggs.
Thank you.
Madam Chief Justice, and may it please the court, my name is Leanne Helch, and I am here to rebut on behalf of the appellant. When arguing that Ms. Innocent relinquished her citizenship, the respondent stated that Ms. Innocent is an 18-year-old and considered an adult, so she could not have been under force or any outward influence. Though Ms. Innocent can be labeled as a legal adult, reaching the age of 18 does not mean one is a mature adult and capable of living independently. Ms. Innocent was still dependent on her father, and by signing the oath, Ms. Innocent risked being outcasted by her family and causing her father to lose his job. In Pavlikita, the court held that rights of citizenship are not to be destroyed by ambiguity, and the facts in this case, proving that Ms. Innocent did the act both voluntarily and with the intent to relinquish her citizenship, are extremely ambiguous. They also stated that Ms. Innocent felt no loyalty to the United States. This was disclosed 2 years after relinquishing her citizenship, and simply because she felt no loyalty to the U.S. 2 years later does not mean that she was disloyal. By signing a loyalty oath, Ms. Innocent may have not understood that the document implied that she could also imply that she intended to relinquish her United States citizenship. She only understood that she was signing away her loyalty to save her father's job. They also argued that by going to college, Ms. Innocent used her citizenship as a fair weather citizenship and did not actually keep it. But Ms. Innocent, by going to college, Ms. Innocent showed that she still believed that she was a citizenship, and from this we can infer that she never intended to give up her citizenship.
When attempting to prove that Miss Innocent in fact did commit treason, the opposing counsel argued that she was knowledgeable that her boyfriend was a radical Muslim with anti-American views. Though this is true, Miss Innocent had no other reason to suspect that her boyfriend was a terrorist and had not known him to build bombs in the past. She cannot be expected to have lost trust in her boyfriend and labeled him a terrorist simply because of the statements of a stranger. They also argue that a ham radio at this time is irrelevant. It is not Miss Innocent's job, and it is not the job of this court to judge what she believed to be her boyfriend's hobbies. Though the clerk...
Counsel, let me interrupt you, because didn't she also have some understanding of his political views?
Yes, Your Honor, but it is an extremely large jump from these parts cannot be used for a ham radio, so these parts must be used for a bomb.
What about the fact that he didn't want to go out himself to purchase them and felt that for some reason he needed her to go out and do it? Aren't those, the combination of those three things something that should have weighed on her mind?
Your Honor, that may be true, but she simply believed that he was asking her that because of the event's proximity to 9/11. And typically, men are judged more to be terrorists than women, and he might have believed that his girlfriend was safer buying the parts than him. Undoubtedly, he did use her to do this, but Miss Innocent did not draw that conclusion and was not aware of what she was doing. The clerk did in fact say that he could not imagine how the parts could be used for a ham radio, but Miss Innocent has no prior knowledge of how bombs are constructed, and any reasonable person cannot be expected to make the large jump from that to the fact that the parts were going to be used for a dirty bomb. In the House dissent, Justice Murphy asserted that not every act that gives aid and comfort to the enemy constitutes an overt act of treason, and Miss Innocent was simply running an errand for her boyfriend, as many people in relationships do.
Counsel, the government, has argued that the wholly innocent acts are enough to constitute treason. Should we depart from that rule, and if so, why?
Your Honor, may you please rephrase the question?
The government has argued, and from what the cases say, wholly innocent acts such as Mr. Hawk renting a room for his son, things like that, can still constitute acts for treason. Are you saying we should depart from that rule, and if so, why?
Your Honor, not entirely. This contrast helped because in how he was going and buying parts for his son, knowing that his son was aiding the Nazi cause and helping them. Miss Innocent was not aware of her boyfriend's intentions and thought that she was just aiding him in buying parts for something that he was going to build. That's the very large contrast between the two. When arguing that Miss Innocent should be classified as an enemy combatant, the respondent stated that it is in the best interest of the United States for Miss Innocent to be labeled as an enemy combatant. Miss Innocent is not an inherent leader to the United States, and we cannot allow her to be lost in the shuffle. Miss Innocent has no prior record, and the court cannot label her as one solely based off of facts that the government has not disclosed.
Thank you, Ms. Coach.
Thank you.
Madam Chief Justice, and may it please the court, my name is Catherine Chow, and I am here on behalf of the respondent to rebut the opposing counsel's arguments. Regarding the issue of citizenship, the opposing counsel stated that taking an oath after having obtained the age of 18 years means relinquishment of citizenship. And as we see in Nasso's case, she fulfills all these requirements. She is an 18-year-old, she voluntarily took the oath, and the oath was an exclusive loyalty to Indonesia. This alone should be able to make her this alone should be liable to make her lose her citizenship.
But counsel, from the record, it appears that Ms. Innocent did not take her United States citizenship too seriously. So why shouldn't we infer that her signing the Indonesian loyalty oath, that she also didn't take that very seriously?
She used her United States citizenship as a fair weather citizenship because after having signed the oath, she returned to the United States after 2 years simply to use it for college benefits. And because of that, she must have taken into some consideration her United States citizenship. And as an 18-year-old, she is educated and she should know the meaning of exclusive. And so therefore, while signing the act, she should know that she would be giving up her United States citizenship while she was signing the act. Additionally, the opposing counsel compared the Kawakita case to Nasso's case. However, in Kawakita's case, Kawakita merely signed a koseki, which was simply a family census register stating that he was a citizen of Japan. However, Naso signed, again, an exclusive loyalty oath to Indonesia. We must pay special attention to the word exclusive because that means that she should be aware that she was giving her allegiance to Indonesia and to Indonesia only. Regarding the issue of whether or not she committed treason, the opposing counsel stated that she bought the parts out of trust. However, you cannot simply use trust as a shield for her ignorance. There are so many clues that suggest that she should be aware of her boyfriend's views. For example, when the clerk stated that he cannot imagine how these parts would be used for a ham radio. Additionally, as stated by one of my counsels, her boyfriend and herself look American and they look Western. There should be no reason why her boyfriend would be any more afraid of prejudices at following of 9/11 because they look similar. So therefore, there should be no reason for him to suspect that he would be under attack of prejudices while she wouldn't be.
As a counsel, should we disregard whether Ms. Innocent did in fact trust her boyfriend and bought these items out of an act of trust? Should we disregard that? And
No,
if so,
Your-
why?
No, Your Honor, we should not disregard that, but however, we must look for all the circumstances surrounding the events. There are so many clues pointing to her knowledge of her boyfriend's intent that we cannot simply disregard all of these and say, oh, just because she trusted her boyfriend, we must disregard all of these clues pointing of her intentions. Additionally, we must also consider the fact that she knew of her boyfriend's anti-militant views, and and the trust argument can also be used against her. Because she was close with him, he should be more knowledgeable of his views, and therefore it would be more probable for her to know of her boyfriend's intent. Regarding the issue of whether or not Naso is a military and is an enemy military combatant, the opposing counsel stated that there was no direct order from the president. However, we see in the Hamdi case that Hamdi himself had no direct order from the president, yet he was seen as an enemy combatant anyway. And in this case, in Naso's case, we must also see that even without presidential order, she can still be classified as an enemy combatant.
Do you think it's good for society for us to just, whisk people away anytime that they do anything that helps an individual to military bases and have them tried as a military enemy combatant?
No, Your Honor, it's not good for society. However, Naso is not simply an ordinary citizen. She had the potential to. She potentially put in danger thousands of American lives, and we cannot simply disregard that. Additionally, we must also look at in the context of her actions. This was following shortly after 9/11, and so therefore it is reasonable to assume that there were other intentions, and we cannot simply treat her as a simple, ordinary citizen. Additionally, the opposing counsel stated that she had no intent to aid or abet terrorism, and as I stated